Application Autostore Technology AS against Ocado Group PLC and others.
Yes, Mr. Davies.
My lords and my lady, I appear on behalf of the defendants to the principal action and the claimants in the breach of confidence action, the applicants in this application, along with Mr. McLean QC and Mr. Claimant QC, who appeared below. I'll refer to my clients, if I may, as Ocado throughout. Mr. Flynn QC and Ms. Pickard, who both of them appeared below, appear for the claimants in the principal action, and the corresponding parties in the other action on the application. I'll refer to them as Autostore. As you're aware, this is an appeal from the order of, or the refusal to make an order of His Honour Judge Hacon, sitting in the High Court, refusing Ocado's application for an interim injunction, an application that was made to restrain the use of certain information by Autostore in US patent proceedings before the International Trade Commission. If you're not familiar with that institution, it is a court dealing with applications to bar the importation of products into the United States, in particular based on infringement of US patents. The information concerns confidential communications and without prejudice negotiations that took place between the parties at and in connection with 3 meetings that took place in mid-2018. The meetings are collectively referred to in the judgment, and I'll refer to them as the London meetings, and the information passed in the course of and in connection with those meetings as the London discussions. Can I just mention 2 things at the outset so far as today's hearing is concerned?
Yes.
First of all, on timing, the parties are agreed there should be, subject to your lordship, your ladyship, an even division of time between the parties. And I also intend that Mr. McLean will deal with the respondent's notice issues on our side, if that's...
Well, you're going to deal with those in reply, presumably.
Well, it depends very much on how it proceeds. My suggestion was that the easiest way to deal with it was that I open the appeal, that Mr. Flynn responds and opens on his respondent's notice, and that Mr. McLean will then respond on the respondent's notice. We're really... I could then make all the points that I wish to make in reply. Maybe that's the most suitable thing, or Mr. McLean could do that in the course of his...
Well, let's see how it goes. But you open your appeal. We've done a lot of reading.
I'm grateful.
Mr. Purvis, I think we're pretty up with the issues. It's not all that complicated.
It's not that complicated. There are just a lot of issues, and it may take a little longer than perhaps it should, just because of the number of issues being run.
Well, it won't take longer than 4:15 this afternoon.
No.
Mr. Purvis.
Mr. Purvis, while you're talking about housekeeping, can I ask you, will we be receiving a hard copy transcript at the end of the day?
I'm sure you will.
Just for the purposes of note-taking.
A transcript is being made, and I'm sure you'll receive...
Well, we've got it coming up on the screen.
Yes, we'll ensure you receive a hard copy.
Thank you very much.
When it's available, presumably about 6 o'clock or thereabouts. The second thing is confidentiality, and there's been, I know, a little correspondence with the court already. Plainly, we want to avoid making public disclosure in the course of this hearing of the contents or character of documents, which is the whole point of this application, to maintain protection for. But also, the principle of open justice must apply. And the parties have agreed in that respect that there should be an order in advance that references to documents marked confidential in the bundles shall continue to apply even if those documents are referred to in open court. What we a proceeding which is pretty common in the High Court, and I'm sure
Exactly. Yes.
the Lordships are familiar with this.
And,
as well.
and have you drafted an order,
We have-
agreed order?
I
that-
have got an agreed order now, hot off the press. If I could hand up.
Can you make sure that
what's
any
agreed.
hard copy documents are sent by email? I'm afraid I
Yes,
don't use paper.
we'll do that.
Thank you.
So there's really the order itself. You'll see on the second page that 3122 restrictions shall continue to apply to any document disclosed by other party and marked or otherwise identified by the party as confidential in the appeal bundles. The witness statement shan't be open to inspection without redaction. of
Yeah, we've read that.
and so
Yeah.
on. The
Fine. And you've provided or made available redacted copies of your skeleton arguments?
Yes, that's the thing that has been agreed most recently. The parties have finally agreed redactions to the skeleton arguments, and they will be made available in that form.
Right, well, we'll make that order, shall we?
Yes.
Yes. We'll make that order.
I'm most grateful. That will help. The other point, of course, is in the course of my submissions, I may be referring your lordships, your ladyship, to documents which are marked confidential.
Well, you won't read them out, you'll just invite us to read them.
Exactly. And I'll use generic terms where necessary.
Yeah, if you absolutely need us to go into private for a moment, we can.
I'm grateful. I'm hoping very much that won't be necessary.
I doubt if it will. I think these are legal questions.
Yes. I can announce at the outset the primary document that your lordships are aware of, whose disclosure to Ocado is sought to be put before the US court. The judge referred to it as the document in issue because
Yes, well,
using
that's-
any other name might reveal its contents.
Just call it the document.
And I will use that term as well where
Cut
possible.
down extra words where we don't need them.
The document. I'm grateful. Just before embarking on the substance of my appeal, I should note one point just to discount it. Autostore's skeleton argument in reply, in passing, in paragraph 14, makes what appears to be a serious accusation that Ocado is seeking to put, quotes, a false evidential position before the US court. I should say, so far as we're concerned, that's a baseless allegation. We note that it's not supported by any evidence that any statement that is being made to the US court by Ocado is false. It may be a slight overexcitement by counsel in drafting, but really what was intended was the accusation, which I think is what they're really saying, that the position before the US court is evidentially incomplete. But that, we submit, is rather a different matter and is the kind of thing that one gets inevitably when one has without prejudice discussions.
Well, I understand that you suggested that you'd be happy for this document
Yes.
to go to the US court if everything else went with it.
And that was the point I was going to make.
And that was rejected.
Yes.
Well, there we are then.
Yeah. I'm grateful.
And there isn't a suggestion, it wasn't put to the judge, or the judge didn't deal with the question that this was covered by the fraud exception to without
Well,
prejudice, was it?
I think the correct position is, as I understand it, the argument made before the judge in the skeleton arguments, at least by Autostore, was at least to reserve that position, or possibly even positively to argue that there should be another exception created for this situation. on the Unilever and Procter & Gamble principles. They didn't put the fraud exception forward, but I think that their potential argument was there should be another exception of unconscionability or something of that kind. The judge didn't deal with that, and it has not been made the subject of respondent's notice. So I'm proceeding on the basis that that is not a defence which is being relied on.
Well, if it's not in the respondent's notice, it's not before us.
I'm grateful. Can I just now open our appeal in a nutshell, because we say actually it is relatively straightforward once one cuts through the analysis. We submit that the fundamental error of the judge here was his crucial finding that it was unclear on the evidence before him which party had the stronger case, and his consequent refusal to determine the merits in any way as between the parties. And that's paragraph 68 for your note of his judgment. We submit this is a case that cries out, unusually in interim injunction cases, but this case cries out.
I'm just had a note, Mr. Purvis, saying the live stream for the appeal should stop or not. What do the parties say about that? Is there any reason why the legal issue shouldn't be live streamed in the usual way?
Yeah. Well, no.
Just for the purposes of those looking at it on the live streaming, if there is a reference to a document that is confidential, that document is not available for inspection and is to remain confidential, as the order that I have just made provides. Thank you.
Sorry, I'll just go back on that. We say this was a case actually that cried out for a determination on the merits, because
there couldn't be a determination, but there could be an evaluation.
I'm sorry, Muller, that's a much better word. An evaluation of the merits. The judge had the relevant evidence as to the making of the agreement to negotiate, and it wasn't actually in dispute between the parties. He should have recognised that since the application was effectively going to be determinative of the dispute, and since he had all the evidence he needed to take a clear view, justice could practically only be served by taking a view on the merits and granting or refusing the injunction accordingly. In other words, we submit he should have taken precisely the approach taken by Mr. Justice Lloyd, as he then was in Instance and Denny, which is, we submit, the leading authority in applications.
And that's been approved by this court?
It has.
Yeah.
What sort of evidence might be available at the trial of this issue that was not available at this stage?
Well, we submit none. The issue actually is one of construction of the agreement under which the parties embarked on and continued with their negotiation process. One has the evidence as to what was said at the meetings. It's not contested, and no one's ever suggested that Mr. Ayrton's evidence about what was said is to be challenged. And one has the exchange of emails which included the document and which included arranging for the discussions to take place.
There's some evidence as to what your people intended, but that's not admissible on a question of construction.
We say almost certainly not admissible. One always has to hesitate a little over this, because I know Lord Hoffman has expressed views on the potential admissibility of intention on oral agreements.
Yes.
Well, I think we can. We don't need to go there in this case.
We certainly don't put it forward as part of our case, and it's interesting to note that in none of the evidence on the other side is a contrary intention actually advanced. So insofar as it was relevant, there's nothing to suggest that it's going to be in dispute, but in my primary submission, it's not relevant. We're interested in what an objective bystander intelligently looking at what was said between the parties would deduce as to their intentions as to the contractual terms at the relevant time. So we say really that's where the judge went wrong. I note in passing that in paragraph 70 of his judgment he comments that he thought it was remarkable that neither party before him in the oral submissions had actually addressed the balance of harm under traditional American cyanide principles. And we submit actually it's not remarkable given the circumstances of this case. The parties were strongly arguing the merits of their positions on what was essentially the agreed evidence as to the negotiations.
I mean, is it the case that if this court, or indeed Judge Hacon, had granted an injunction, that will be the end of the matter as regards disclosure to the US court?
That's certainly the basis on which the parties have proceeded, because obviously in those circumstances, any continued reliance on the document before the US court by Autostore would be in contempt. And there's certainly no suggestion on their side they would take that risk. So that's the basis, I think, on which the parties proceeded below and are proceeding today. We submit the approach taken by the parties below is consistent with the position that I've just outlined. It's inevitable in cases of this kind that the merits take centre stage, and they are, in the end, in cases of this kind, the only way of approximating to justice and complying with the overriding objective. Even looking at cyanamide, first of all, we submit the whole point of cyanamide and the guidelines that were constructed there was to reflect the risk that the evidence that the judge had at the interim stage would be different or would not be backed up by the evidence at trial. Something that there is no reason to suspect is going to be the case here. Secondly, even in cyanamide, where the balance of harms are considered to be essentially even, one then turns to look at merits or preserve the status quo, which I'm not sure really works in this case. And in a case where the determination at the interim stage of an interim injunction is going to be determinative of whether the claimant has the benefit of the protection he says he's got under a contract, then the harm on either side is going to be essentially the same. In the one case, the claimant is deprived of the benefit of his contract, if he's right. In the other case, the defendant is wrongly imposed on by a term that doesn't exist, and the procedural consequences follow. So we submit that's really where the judge basically went wrong. Beyond that, it gets a little more complicated, because of course what the judge did was to apply a particularly high test on the merits of the case by parity of reasoning with the anti-suit injunction cases, which injunctions are granted against foreign proceedings on the basis of arbitration agreements, which are enforceable in the UK courts. He took that analogy to this case and said, as in those cases, you should have to prove a high probability of success. Now we say, looked at logically, if we're right on the first point, and the judge actually could determine the merit, could evaluate the merits and recognise what the result of the case should be, because the evidence as to the making of the contract was clear, then inevitably he would have to find, let's say he was in favour of the claimants, that there was a high probability of success because he thought the contract meant X and X supported the injunction. So that should not have really made any difference. But we do say, in fact, that's the wrong test. That anti-suit.
You say in law that's the wrong.
In the wrong test in law. I'm sorry. In the wrong test in law because on any view this is not an anti-suit injunction case. I'll come to the authorities on that briefly. But essentially we say they are all about the comity problem involved in actually prohibiting a foreign action from taking place at all.
What's the leading authority on the situation where the outcome of an interlocutory injunction application is determinative in the sense that there will be no point in a trial thereafter as to the evaluation of the merits? What's the leading authority on that? What at the highest level? Is there a Supreme Court case on that?
That's a good question. It clearly was the reasoning of Mr. Justice Lloyd in Instance and Denny.
Yes.
But obviously that's not at the highest level.
No, but that's approved in Prudential.
It's the Court of Appeal of
yes.
and EcoBank, which I think is what the case
EcoBank.
I'm grateful.
I have at the back of my mind a case called Hadmore Productions in Hamilton, but it's quite an old case. I think that was House of Lords.
Yes, I mean there are a series of cases on clear breaches of negative covenants, which are essentially founded on the same proposition, but where there is a clear breach that you will determine the case on the merits. Cambridge Nutrition, I'm being told, and the BBC, which I think is in the bundles, JA1 tab 12.
Yes.
I think maybe that is the case I was feeling for. That's a decision of the Court of Appeal. Yes. Yes. If one looks at the head note, tab 12, it's essentially point 1 of the head note. Where neither side interested in monetary compensation, the decision on an application, injunction, an interlocutory injunction with the equivalent of giving final judgment, and in particular where the subject matter of the application was the transmission of a broadcast, etc. The court should not grant an interim injunction merely because the plaintiff was able to show a good argument case of balance of convenience lay in favour of granting, should assess the relative strength of the parties' cases. That we say.
I seem to remember that actually American cyanamide, I mean, one doesn't read American cyanamide very often, but I seem to remember there is some reference in American cyanamide to that being the position, or to there being a special case where the outcome is final.
Mr. McLean nods, and
Yeah.
We will try and find you that. I don't think that case is in the bundles. As
No, of course not.
So
It's
often
probably
it is.
the most relevant one then, Mr. Purvis.
That's always the way. So yes, and yeah, that's we from Cambridge Nutrition actually is very clearly expressed as far as that's concerned. And it's not uncommon that one has cases of something that is ephemeral, like a broadcast, or something that is either going to happen or not over a very short period, like putting in documents in US proceedings. Once they're in, they're in. It's an entirely logical and common sense proposition that to decide essentially the outcome of the dispute based only on balance of harm and an arguable case would be unfair to both parties, depending on the situation. Can I now turn to what we say about the law and the way in which the facts of this case, the law applies to the facts of this case. This case is founded on the enforcement of an agreement to negotiate on a without prejudice and confidential basis. And authorities on such agreements and the consequences of disclosure of information under those circumstances are multitudinous, and many of them are in the bundles in this case. But the policy of the law is now very clear, and if your lordships want to see it, it is best expressed in the famous passage from Lord Justice Robert Walker in the Unilever case, which is at JA1 tab 17 at pages 267 to 268. Russian Tompkins, which is cited by the learned judge earlier in his decision, makes a similar point. Essentially, that the that public policy recognises the importance of freedom of expression during negotiations, so the parties are not fearful of anything that they may say coming back and being used against them on a subsequent occasion. It goes without saying, and it's not denied in this appeal, that this basis for discussion is well recognised by English lawyers, and that they understand the term without prejudice embodies and, as it were, codifies a contractual agreement as to the circumstances in which negotiations are taking place and the protections that are attached to them, and has implications so far as admissibility is concerned in UK procedural. And what is clear on the authorities, both from Instance and Denny and from Prudential, is that where parties have agreed to use material which is exchanged in the course of without prejudice discussions for the purpose of settlement discussions only, there is an extraterritorial jurisdiction, so far as the UK court is concerned, justifying injunctive relief, which would prevent the deployment of that material in a foreign action. And the clearest explanation of that is Lord Justice Chadwick in the Prudential case, which is at tab 21 of your first authorities bundle, paragraphs 22 to 23. And although in that case, not least because no one had ever said that the discussions were without prejudice, the application failed. The legal basis of analysis here is, we submit, clear. He starts really at 21 by pointing out that, as Lord Justice Oliver pointed out in Cuts and Head, you can't look at public policy as being the overriding point here, because there are circumstances in which the rule operates to defeat, not promote, the underlying policy of encouraging parties to settle their disputes. But in those circumstances, the rule has to be justified on the basis of an agreement. The negotiations will be conducted on terms that, if the negotiations fail, they will not be relied upon in subsequent litigation. In those cases, the court doesn't have recourse to an implied contract as to the mechanism by which effect is given to an underlying public policy. It recognises that effect must be given to a contract, which, if not expressed, may fall to be implied from the circumstances in which negotiations took place, notwithstanding that by giving effect to that contract, the public interest, encouraging parties to accept realistic offers of settlement, is frustrated. And then there's a reference to Lord Justice Hoffman in Muller to an implied agreement based on general usage and understanding. The party making the offer would not do so, that is to say, wouldn't refer to a without prejudice offer. There are cases where the rule can only be justified on the basis of public policy. That is to say, where it can't be justified on the basis of an implied contract. Say, because the party against whom it is invoked was not party or privy to the negotiations. And he then says he would accept that in cases where a restraint on the use without prejudice material can be justified on the basis of an implied contract, a fortiori, when that's governed by English law, and whether or not it could also be justified independently of contract on the basis of public policy, these courts can give executorial effect to the restraint by an order enforcing the contract. And he gives instance in Denny as an example of such a case. In particular, the observations of Mr. Justice Lloyd and some passages we'll look at. What is required in such a case is a finding, or, he says, on an application for an interim order, a real prospect will be a finding at trial that the parties agreed or must be taken to have agreed communications in the course of negotiation wouldn't be used in the litigation then current or any subsequent litigation. Or more precisely, they agreed or must be taken to agree to restrict the use in terms apt to cover the particular litigation in relation to which the restraint is sought. And then he says, I would myself think it necessary to be very cautious before making an order in terms as wide as that sought by paragraph 4 of the draft order attached to the application in the present case. I think my learned friend suggests that he's saying there one has to be very cautious generally before making an evaluation as to the restrictions which may have been agreed by the parties in the course of without prejudice negotiations. We submit that that's not a proper reading of this sentence. He's talking, of course, in circumstances where the words without prejudice were not used, and he's talking about the width of the terms of the order that is sought. He's certainly not, we submit, suggesting some different rules so far as the standard of proof or the burden on the
well, I mean, he seems to be approving the instance decision at pages 888 to 889 and 884.
Yes, and that decision was on, as it happens, on facts remarkably similar to the present case in terms of the language used by the parties. The fact that the agreement related to negotiations over a period of time, various different meetings and various exchanges, and that it was sought to be relied on to prevent the deployment of material in the United States. And we'll go back, if I may, shortly to what Mr. Justice Lloyd said there. Can I just make one further point on the law in passing? We submit in this case the judge and certainly my learned friends tend to elide the procedural question of the admissibility of evidence and the contractual obligations imposed by covenants not to deploy evidence. And even in the prudential...
Sorry, so can you say that again?
Yes.
The procedural question of the admissibility of...
Evidence.
Yes, and
the contractual obligations and covenants which may be entered into by parties governing their ability to deploy information, particularly against the interests of the other party, to the negotiations. Plainly, the two are related, and the without prejudice rule in the United Kingdom, at least in part, derives from contractual obligations undertaken between the parties. But they are in fact different things. One is a procedural rule of a court on questions of admissibility, and the other is a substantive right to prohibit the use of information.
Do they have any practical difference in relation to English proceedings?
Your Lordship's right, insofar as English proceedings are concerned, they don't. So when we look at instance of Denny, one can see why, because what happens is the implied agreement is said to be subject to the Unilever and Procter & Gamble exceptions. Yeah. So it becomes entirely circular. But it does matter when one's considering foreign proceedings.
Because admissibility is obviously a matter for the forum.
Which everybody agrees in this case, it's a matter for the Lex Foreign. And in our submission, it's always going to exist. Whatever the rules are of the forum, they're always there. And yes, you enter into your agreement, as it were, against the background of those, but you don't have to know what they are, because you are making an agreement as to substantive entitlement, substantive covenants not to use.
Is your submission that the agreement without prejudice made in an English contract in London is effective anywhere in the world to prevent it being deployed in evidence in any litigation in any country? Anywhere? Always?
Yes, if that is a proper construction of the agreement. That the extraterritorial jurisdiction recognised by Lord Justice Chadwick in the passage we've just looked at would indeed enable that right to be enforced. And it's a substantive and in personam right against an individual party to the agreement.
So it's not so outlandish in a case like this where proceedings are going on in multiple jurisdictions and therefore you know what you're talking about. If you meet together in London to settle proceedings in America, France, Germany and England,
yes,
it would be hardly surprising that you agreed that the without prejudice rubric should apply to all those jurisdictions. So,
yes.
I mean, whether it applies all over the world probably doesn't matter.
Well, we submit this case is particularly clear. There may be edges, blurred edges, and certainly what Mr. Justice Lloyd says in instance of Davies, because he's talking about future proceedings. He says, well, if you would contemplate that future proceedings are likely to occur, and you will do automatically if you are patent lawyers arguing about patent portfolios which are international, and you know that the businesses are international and you're going to clash all the time, then that is a proper construction. I think he says if you've got a couple of parties that just bumped into each other because they'd had a road traffic accident and then had some negotiations, you might want to think about what was really intended if they ever came up against each other again in relation to a commercial contract dispute in a completely different jurisdiction.
What is the evidence in this case about the likelihood of US proceedings at the time of the London meetings?
Yeah, it is common ground that they were contemplated when that was the very purpose of the document.
Well, it's referred to in the document, isn't it?
Implicitly, if not, your Lordship may be right. There are certainly numerous references.
Well, it's not much.
The whole context of what was going on, so far as the US is concerned, was potential proceedings Yeah.
You'll see a number of bullet points there, or numbered points, and you see the references.
I'm grateful. I'm told Mr. Ayrton's statement deals with this. It's supplementary bundle, tab 5 from paragraph 9 onwards. And I'll be surprised if it's not in the judgment, actually, itself. But I don't think there's any dispute about that in this case. It's perhaps the quickest way of dealing with it. That is not one of the issues. In instance in Denny, it was a potential issue because they were talking very much. The proceedings may not specifically have been contemplated, but Mr. Justice Lloyd says, "Well, look, your international businesses, you've got international portfolios of patents, and inevitably, that's the whole point of having without prejudice negotiations." Yes, I'm told. Yes, the judgment of His Honour Judge Hacon, paragraph 7, summarising the position. Yeah. Yes. Relationship's reference to the document itself, though I'm chary about going there in case I say anything I shouldn't. But
Well, just tell us where it is. It's in the core bundle.
it's in the supplementary
Supplemental.
bundle. This is actually the attendance note. Yeah. I think
I think it's tab 15 at page.
document itself.
Tab 15, supplemental 70.
Yes.
6 starts a bit earlier than that.
Grateful. Yes.
I think the passage I was referring to was at tab 17 at page 87.
It's 17, yes, it's the minutes of the meeting. Great.
Yes, my lady, I think also that page 85.
Thank you very much
Yeah.
indeed.
The general point I was making about the distinction between lex fori rules of admissibility in evidence and substantive agreements as to confidentiality does come out of some of the discussions in the textbooks, and in particular I'll just perhaps refer you to Zuckerman, which is at JA1. Sorry, it's a bad reference.
So you're in authorities 1, are you?
Yes, sorry, I think I may have been using an old version.
Tab 8 is
Must be tab 8 at 17.24. I beg your pardon.
Zuckerman on civil procedure.
Page 63.
Yes. Without prejudice rules a rule of procedure, and its effect therefore cannot be exported to foreign proceedings, in which matters of procedure are governed by the lex fori. Court of Appeal held an English court couldn't restrain a party from using without prejudice communications exclusively on the grounds that they're protected by immunity and inadmissibility. So that's prudential. However, it also held that an English court can restrain a party from breach of contract governed by English law regardless. Breach may take place here and abroad. Therefore, where a party can establish there was an agreement by the parties to negotiate without prejudice, would enforce such an agreement. I mean, that's again the bit we looked at in Prudential. He doesn't cite instance in Denny, perhaps slightly surprisingly, but that, of course, is the case that Lord Justice Chadwick was referring to. And a similar point is made in G on injunctions.
Do we need the textbooks when we've got the decision itself?
My Lord, almost certainly not, and I won't trouble you more with it. It is a, we would submit a straightforward proposition, but there's a tendency we submit in this case on the other side to elide the two.
Well, you say they elide the
Yes.
distinction, and you say it's perfectly clear if you make
Yes.
an agreement that something is to be confidential and without prejudice
Yes,
everywhere, it's to be confidential and without prejudice everywhere.
right. So what of this case? The evidence shows that the parties consistently, in this case, from the beginning, used the terminology confidential without prejudice and for the purpose of the settlement negotiations only. And we've summarised in paragraph 28 of our skeleton the consistent references of the parties. That's at the core bundle, tab 8, paragraph 28. The evidence as to what was said prior to the first meeting was given by Mr. Ayrton and is not disputed. It was said to be without prejudice and confidential. Even as late as 21st of May 2021, as we summarise at the end of subparagraph 1 of 28, Autostore's patent attorney was making clear that the discussions were held on without prejudice and confidential basis. And then we have a chain of multiple emails in 2018 between the parties, all of which actually relate to the third meeting, every one of which, from both sides, commences confidential and without prejudice. The document itself, we refer to in subparagraph 3, well, your Lordship has already seen all this, but was explicitly and very carefully headed in the same way, indeed on every single page, not only confidential and without prejudice, but provided for purposes of the settlement negotiations only. Worth pointing out, of course, the document was delivered under these circumstances prior to the third meeting, where the statement that my learned friend makes such reliance on was made. But we'll come back to that. And
It was presumably sent by Autostore's lawyers to Ocado's lawyers.
Yes,
Marked in the way we see.
that's right.
Can I be sure that I'm clear which document it is?
Yes.
Tab 15
tab
in the
15.
supplemental bundle.
Yes.
There's a number of pages. But is it just the 2 pages which
It's
refer
really page 77.
77 and 78?
And 78.
It's just that, isn't it?
That's the key. That
Sorry, I'm not with you. It's in which bundle?
I'm sorry, it's in the supplemental bundle
Page 77.
of tab 15,
Yeah.
and it's sub 77. So this is the internal numbering of the.
Well, sub 77 is part of the document itself.
Yes.
Right.
But
When
it's
you
those
say the document, do you mean those 2 pages which refer to a particular US patent, or do you mean the entirety of Exhibit 50?
It's, there are 3 numbers there which are referred to.
Yeah. Yeah. It was sent under.
Can we look at the email under cover of which it was
Yes,
sent?
which is. Well, this was. Yeah, sorry, I'll find it. Or is it? You have the chain of emails at tab 14, and the one that brought with it this one is on sub 66, the one that attached the
Please,
document.
please find attached,
If you've got SUP 66,
and it's the third item listed in that.
yes, that's right. So headed confidential and without prejudice.
Yeah.
So the terminology was consistently
So
used.
Bristow's Act for Autostore.
Yes, at the time.
Yeah.
And both the relevant sets of lawyers, Bristows and Powell Gilbert, are presumably London solicitors.
The London solicitors specialising in particular in patent litigation and, of course, international patent litigation. So that's the document and the email it was attached to. Maybe while we're on it, if you've got that still open, I will be referring later to the document that came after the meeting, which is the very first document in the very first email in the chain behind tab 14, sub 60. Because as you see, this is 3rd of August from Bristow's, headed confidential without prejudice for the purpose of settlement negotiations only, and this also continues the discussion in relation to the point which was raised in the document. You see that just below the second hole punch. And you see at the end of the first paragraph, for the avoidance of doubt, all information in this email is provided on a confidential without prejudice basis for the purpose of settlement negotiations only. So right the way through the entire period of the negotiations, the language used was, in our submission, entirely consistent so far as the parties are concerned.
Well, you say for the purposes of settlement negotiations only means what it says.
Yes. It's hard to imagine how one could have been more clear about the intentions.
We're not just satisfied
use.
with without prejudice, which might be said to have a parochial meaning.
Yes.
This is documentation about overseas patents,
Yes.
and it's said to be for the purposes provided for the purposes of settlement negotiations only.
Well, Lord, yeah. So in some ways, stronger case than instance. It might be worth looking how, perhaps just to compare this with instance, because we say exactly the same reasoning as used by Mr. Justice Lloyd, so far as characterising the implied contract between the parties applies. So instance and Denny is behind tab 18 of JA1. You'll see the circumstances in which the particular communications were exchanged are explained between 276 and 277 of the numbering, of the bundle numbering, where he takes this part of the history from 3 paragraphs in the witness statement of Maria Danilunas for the claimants. And it should be said, like the present case, this was a patent dispute in which the negotiations were being carried out with the assistance of specialist patent solicitors. At the top of 873, both prior, and sorry, I should also say this part of Miss Danilunas' evidence is recorded by Miss Justice Lloyd as not having been in dispute. Both prior to and during the course of 91-92 UK actions, without prejudice letters and other confidential communications such as agendas, notes and meetings, telephone conversations passed between the parties, furtherance of efforts to settle. Content wasn't limited to settlement of the particular piece of litigation, included discussions relating to settlement of worldwide patents and other disputes, current and future, such as the protection afforded in other countries to the imprint patents of the subject of the UK actions, and possible future worldwide disputes between imprint, Denny, FAF Int, FAF licensees in relation to other patents. Those were related companies. Denny wished to negotiate a benefit for its worldwide licensees, and inevitably settlement discussions were on a worldwide basis, covered the period 91 to 93, significant amount of correspondence, generally headed without prejudice, and passed between Mr. Instance at Imprint and Barry Denny, the managing director of Denny at that time. And then there's a reference, and between their respective solicitors. Then there's a reference to them attending without prejudice meetings, lengthy telephone discussions, number of occasions they met without their lawyers. Beginning of the meetings was the practice, Mr. Instance, to make clear the meeting was on a without prejudice and confidential basis. And this included not only the content of the meetings and correspondence, the fact the meetings were taking place. Denny, without hesitation, agreed to such conditions and also requested such treatment in letters and at meetings, etc. You see then after that he says that part of externalness as evidence wasn't in dispute. And he then goes on to deal with other parts of the matters that were in dispute, but really the key part of his judgment in this case, which we say resonates with the present, is his judgment in relation to those communications prior to the settlement agreement, because they were the subject of what he held was an implied contract to protect the information. You'll see that at 280 bundle numbering, the passage which is highlighted. So we're interested here in the first class of material, the without prejudice documents, without prejudice information, which he calls compendiously, see at the end of that paragraph, the without prejudice material. He then, we can skip over the rest of that highlighted passage. And he then deals with the disclosure in the US proceedings, which gave rise to the application. And then at 282 in the highlighted passage summarises the English law as to without prejudice communications at some length, which I don't think, again, I need to trouble you with, because there was a submission being made here that the rule should be limited to admissions, which he rejects based on Russian Tompkins and other authorities, and particularly Unilever and Procter & Gamble. He cites the passages from Unilever and Procter & Gamble dealing with the policy of protecting without prejudice discussions. You can see at the bottom of internal numbering 286, sorry, bundle numbering 286, about 10 lines up, where, so this is Lord Justice Walker quoting Lord Griffiths, first of all, and making the famous remark, parties can't speak freely at a without prejudice meeting if they must constantly monitor every sentence with lawyers or patent agents sitting at their shoulders as minders. Then there's a reference to the abuse issue. And then at the top of 287, he quotes Mr. Justice Neuberger, distinguishing public policy from the contractual grounds. That whereas here the party seeking to resist without prejudice material is able to rely not only on public policy but also on the contractual ground, different considerations apply. Parties are agreeing the contents of the correspondence will not be referred to. in the proceedings in which they are engaged or which they contemplate. Accordingly, none of the contents correspondence may in general be referred to in the proceedings. And he comes back and relies on that as in support of his ultimate conclusion that this agreement should be considered to apply to future and foreign proceedings. And then on 884, he draws conclusion as to the implied agreement in the case before him. You see in the highlighted passage, sorry, 288 of the bundle numbering, the highlighted passage from the third paragraph. So he's here dealing with the facts in relation to the without prejudice communication. He says the present dispute arises between persons who either were parties to the original communications or have obtained them from persons who were such parties and are commercially and corporately connected. And he concludes if there was an implied agreement, they must be bound or at least subject to it. And he says, in my judgment, it's very strongly arguable, indeed probable, that without prejudice communications are indeed governed by an implied agreement. They will not be used in the current or any subsequent litigation between the same or related parties. And then the point made by my Lord Justice Nugee, that contract would give way to the circumstances identified in Robert Walker's 8 exceptions, if any were relevant. As I say, none of them are relevant to this application. It's correct, in my judgment, to regard the protections extending to subsequent litigation. First of all, for the policy reason he then gives, and then makes the point I think I referred to a little earlier. The position may perhaps be different in practice between two parties brought together by the circumstances of a road accident, may never have anything else to do with each other. But the holders of patents in related areas, whether or not they're to be regarded as competitors, may well, through themselves or their licensees, come up against each other in a number of different commercial circumstances, giving rise not only among the litigation prone to several different disputes over time. It can't be assumed one piece of litigation is the last there will ever be. Of course, we're in a much stronger case here, so far as my clients are concerned, because it is common ground that the dispute, as far as the US is concerned, had already arisen, and that negotiations were indeed intended and did relate to that dispute as well. He concludes, and you'll see again at 290, he's going to proceed the basis claims are a good deal more likely than not to be able to show the use in the US proceedings of material arising in the course of the transaction, including the without prejudice letters, would be a breach. I'm sorry, that's a reference to the settlement agreement. Do that. So he's dealt here in this passage we were looking at with the implied agreement insofar as it covered the without prejudice communications. He goes on then to deal with the other categories on 290 and 291. And then for completeness, he also deals with the submission that it should all be left to the US courts to decide what to do, which you'll see he discusses from 291 under the heading, should the question of restraints on the use of the documents be left to the United States court. And in that respect, he refers to Bournes and Hacon, which was a slightly different issue, but related, because the documents that were sought to be used in the United States were subject to an implied undertaking as regards to documents produced on compulsion of discovery. And it was held that that implied undertaking applied to use in the United States, and that it wasn't right simply to leave it to the US courts to decide based on its own internal rules of procedure. And the non-highlighted passage you'll see at the top of 292, the quote from Lord Justice Aldous deals with that point, which again makes the point I was making earlier about the distinction between local rules of procedure and the substantive rights under a contract. And then he concludes in the highlighted passage, if he's right in the conclusions he's expressed, including in relation to the prejudice material, it would be a breach of contract for the FAF parties to use those documents for the purposes of US litigation. He then says the two express agreements are clearly governed by English law. Seems to me the question of whether the without prejudice communications governed by an agreement limiting their disclosure is also a question of English law. And then the reason he gives for that, you will see, is that from the middle of that paragraph, since the only actual litigation was in the English courts till the moment the US proceedings were commenced this year, a can and should proceed on the basis of a major concern, even if the only or conceivably the primary concern, even if not the only or conceivably the primary concern was the settlement of the English litigation. It must at least be very strongly arguable. The question of whether such negotiations took place in the aegis of a contract such as I described is a question of English law. I think my learned friends at some point suggest that that passage was founded on the basis that the only concern there was English law. Clearly that's not right, looking at the way he's expressed himself. He says a major concern, even if not the only, or conceivably the primary concern, was the settlement of the English litigation. He doesn't say so, but in my submission, he must surely have also taken account of the fact that the negotiations were between English solicitors in England, and that again must have affected the decision. And also using phraseology which is known in English law, but there's no evidence is known in any foreign legal systems. Presumably certain other common law jurisdictions, but certainly the without prejudice term is familiar to UK lawyers as having a particular meaning. I'll come back to that in this case, because if I can summarise what we say is the proper legal analysis here, we say, first of all, there's no issue before you that the English court has jurisdiction over this dispute. His Honour Judge Hacon granted permission to serve out. It had been opposed, in fact, on the grounds of...
What was the gateway which you succeeded on?
I'll have to ask for assistance on... Yeah, the contractual gateway, I'm told.
What, the contract was governed by English law or to be performed in England, or what?
That it was governed by English law.
So he must have been satisfied there was a good arguable case to that.
Yes. And that's not been appealed. He made an order granting permission that hasn't been appealed. So that position stands in our submission before you. There's no dispute that there was an agreement between the parties that governed the confidentiality of the discussions of the documents exchanged in the course of the discussions. The only question being argued here is one of construction. The governing law of the contract, we submit that it's very clear this agreement must be governed by English law. It was made in England between English solicitors using English terminology involving the settlement of proceedings of which the English proceedings were live. Both parties plainly needed to understand what the scope of the protection was for discussions that were taking place, and to be able to consult the lawyers that were present at the meetings, who were in fact only English lawyers, to determine how free they would be to express their views. It would be surprising in those circumstances. The contract was said to be governed by a system of law with which those lawyers were not familiar.
What's the test? Is it Rome Convention?
Yes, that would be the case at the time.
So what is the test? Closest and most real connection?
Yes. we've done this. Yeah, I'll show you I think we've got the analysis that we carried out. Where is it? So it should be, yes, in our skeleton below in tab 18 of the supplementary bundle.
I think it's tab 46.
I beg your pardon, yeah. 259 behind tab 46. Yeah, this is the hearing lost on the 10th of June. Thank you. So the submissions on the law of the agreement starts at 257. That helpfully reminds me. Paragraph 29, Rome 1. And essentially the point that I've been making at paragraph 30. And then we refer to Article 3.1. We refer to implied intention by reference to Dicey and Morris and the passages there underlined. And then we say, even if we don't infer an implied choice of law by the parties in 31, that we rely on Article 4, that English law will be the proper law of the contract. Most close connection.
I think what's suggested against you is that part of the contract is governed by English law and part by US law.
Yes.
Which it is possible to do.
It is. I'm going to come to that proposition, if I may, because I think that's my own friend's positive case, and I will address it. I'm coming to it very shortly. Your Lordship's right. I think that is what's being said. We say it's possible, although, given the circumstances of what was going on here, it seems an unlikely thing for the parties to have been provided for a whole series of reasons. First of all, of course, it seems to entirely derive from a statement made towards the end of the negotiation process, after the document had even been disclosed. Secondly, the parties who were negotiating the agreement on behalf of their clients were English lawyers. Only English lawyers were attending the meeting. For the reason I gave a little earlier, it would seem very odd if they had considered that the restrictions that were imposed were restrictions that they themselves did not understand, couldn't possibly advise their clients on in the course of the meeting.
So the agreement's between a Norwegian company and a group of English companies, or does Ocado have other nationality of companies within the parties?
There will be other parties, but I think all the parties to the proceedings plainly are.
Well, who are the parties to the agreement that you allege?
We say they are all the parties to the proceedings.
To the English proceedings.
Yeah.
And who are the parties to the American proceedings?
I will just take instructions on that, if I may. Yes, I think if we go to tab 5 of the supplemental bundle, which is Mr. Ayrton's 7th statement, hopefully tab paragraph. We'll get this information. Yeah.
Paragraph.
So paragraph 7 refers to the US proceedings, which it says are brought by Autostore, which I'm assuming is the Norwegian company, but it's not actually stated here. So I believe that's right, that Autostore, the Norwegian company.
Well, they're defined in paragraph 4. The claimant is a Norwegian company.
Yeah,
The first to fifth defendants comprise members of the Ocado Group company.
yeah,
Doesn't say which nationality.
no. Right. Somewhere we'll find the evidence that the Norwegian company are parties to the US proceedings.
Paragraph
It says
21 suggests that there are a number of complainants in the ITC proceedings, including the claimant.
Yes. Yes, here we are. Mr. Brinkman is probably the best source of this. So this is supplemental. Mr. Brinkman is Autostore's witness. Supplemental tab 28. And he deals with the US proceedings in paragraph 1. So it appears that the proceedings have been brought by, at the top of 164, his client Autostore Technology AS, which is indeed the Norwegian company, and its US subsidiary, which he just calls Autostore. So both of them are parties to the US proceedings.
Are both of them parties to a contract that you allege?
We say yes on the same basis as in Instance and Denny. That, this is a company controlled by.
That doesn't make them a party to a contract, and I don't think Mr. Justice Lloyd said so. I think he said that if they receive documents from someone who is subject to a contractual restraint, they can't use it either, which is a slightly different point.
Yes, although
I mean, what's your pleading? I mean, it's not a question of what you say on the hoof, maybe, who you say on the hoof may be parties to a contract. What do you say is the contract that you allege? I mean, I'm assuming that it's what you told me a few moments ago. It's the parties to the action that we're dealing with here. Namely 6, as I think are English Ocado companies and 1 Norwegian Autostore company.
You've only joined the Norwegian company as a defendant of this claim.
yes, and that's who we're seeking the injunction against.
Where do you
The
allege the
pleading is
contract?
at tab 11 of the supplemental bundle.
Tab 11 of the supplemental bundle?
Yeah,
That's the confidential annex to the re-amended statement of claim. Is that what you mean?
that's it. So that sets out the pleaded case so far as the claim for the injunction to restrain the breach of confidence.
So where's the contract alleged? It says confidential discussions took place.
Yes, so you will see from paragraph 7.
It's 8 is an oral contract was made.
Yeah, between the claimant, which is Autostore AS, the Norwegian
And Ocado, which is the first 5 defendants.
Ocado, yes, which accords with, I think, with what I told you a little earlier. I think may be a...
And
apparently
is there any
somewhere.
defence or anything that alleges different parties?
No, there is no defence to that that's gone in, as I understand it.
Well, strictly speaking, as I understand it,
Yeah.
you've issued a separate claim form
Yeah.
for breach of contract,
Yes.
which we have at the back of the core bundle.
Yes.
And I'm not sure there have been any particulars of claim in that action.
That's true.
And,
This
and
was
what
the-
we were looking at
this
paragraph 11 was a draft
Yeah.
to a re-amendment.
Yes.
But I think the judge thought that it should be in separate proceedings.
And the proceedings were issued, and I think the particulars of claim have not yet been served. So this is the draft pleading, essentially, which will be
Rejigged to form the particulars of claim in the new
Yes.
action.
So the purpose of this was to show
Yes.
the judge what the claim would be.
So the only court document, just to try and be clear,
Yes.
is at the back of the core bundle, and it's called a claim form for breach of contract, issued on the 15th of June between 5 companies with registered offices in England
Yeah.
against Autostore Technology with a registered office in Norway.
Yes.
Permission to serve out having been granted by Judge Hacon and not appealed.
Yes.
Right.
And permission to serve out granted on the basis that it was a contract governed by English law
Yes.
and fitted within that gateway, and under the usual jurisprudence, he must have been satisfied there was a good arguable case to that effect.
My Lord, yes. Yes, it says, I note particulars to follow, and the best material you have on the pleaded nature of the case that was before the judge is, in fact, what you see at paragraph tab 25 of the core bundle.
Well, it's interesting, actually, that the claim form only seeks an order that the defendant
Yes.
shall be restrained from referring to information arising from without prejudice discussions between the parties.
Yes.
It does not refer, and it refers, forgive me, in paragraph 2 to an inquiry into the loss and damage as a result of the defendant's acts in breach of its contractual obligations
Yes.
to the claimants.
Yes.
So it's plainly founded on a contract,
Yes.
and that is pleaded, you say, in tab 11 of the supplemental bundle.
Yes, actually, I'm told that tab 25, which is very, very similar, is the amended version of that. But yes, it's the same as what we were looking at. But I should have said tab. Sorry, tab 26 of the supplemental bundle. There seems to have been an amended version. Is that the one I put before the judge?
But there's no suggestion in the evidence for Autostore that the contract was made between different people or that there wasn't a contract.
No. No, it's explicitly clear the dispute is one of construction of the agreement. No one's saying it wasn't one or that parties were different.
I mean, construction is a funny word to use when you're talking about an oral agreement or an agreement evidenced by multiple documentation. Interpretation at best, and probably not even that. I mean, it is you say the dispute is as to the terms of the agreement.
What did the parties mean when consistently they referred to the negotiations being without prejudice, confidential, and the disclosures being for the purpose of the settlement negotiations only?
And I suppose you say that contracts likely to have been made right at the beginning, and it appears that the documentation relating to all these materials said confidential and without prejudice and only to be referred to for the purposes of settlement negotiations, which is itself the terms of the contract.
Yes. And the only question is, if it is a question, what does that mean? We say, well, actually, it's explicit on its face. It's not really even a question of an implied contract, except in the recent sense. It's the nature of the agreement is tolerably clear. I mean, I should refer to the way Malone Friends put it to be accurate, so that I can address the point that they make. And they've put it, I think they're putting it in the same way they did before the judge, and in our submission the way they put it before the judge is perhaps a little clearer. So if your lordship has supplemental bundle, your lordship's lordship has supplemental bundle at tab 48.
48.
Yeah, you'll find the skeleton argument below.
Yeah.
I think they're still saying the same thing, although, as I say, it's slightly elided. So at 87, which is sup 306, so they're talking now about the merits. They say their position is, as properly construed, the parties' agreement the discussions would be held on without prejudice basis was an agreement that the lex fori would determine any issues concerning whether the contents of the discussions could be admitted into evidence in national proceedings. In other words, English law would govern whether the contents of the discussion were admissible in any future English proceedings. US law would govern whether the contents were admissible in any future US proceedings, and so on. And the "and so on" is actually of some significance, because also contemplated here would have been other proceedings in Germany. The parties were also talking about EPO, European Patent Office, opposition proceedings. So there were a wide range of jurisdictions which, if this was the right agreement, the rules of admissibility were
But
being...
can I just be clear about this? When is this contract said to have been made? Is it said to have been made, I mean, well, a rhetorical question, why is it said to have been made specifically when this document, which happens later to have assumed disproportionate importance, was handed over? But why, I ask rhetorically, is it not the case that any such contract must have been made at the beginning of the negotiations, and not at some intermediate stage, simply in retrospect, because some document that was handed over amongst other documents, as we've seen in the email, assumes of later importance? The contract must be a contract made when the negotiations commenced. And that contract, unless anybody shows anything else to the contrary, is contained or implied from the words confidential and without prejudice, and not to be used in any except in settlement negotiations.
Well, yes, that's what we say.
What else is there to it?
That's what we say, which was, of course, the basis of our application, that from the beginning and consistently throughout, these were the terms that were used. That is good evidence that was the agreement right at the beginning.
But why did we get into all this, if I may say so, all this questions of how many angels can stand on the point of a needle, derived from evidence about who said what to whom about this document?
Well, the reason is the only point that my learned friends can possibly have to take this case away from the perfectly standard, straightforward analysis like Instance and Denny is the statement by Mr. Ayrton at the third meeting, which they put an inordinate amount of reliance on, as you'll see from their skeleton argument in these proceedings, which, as you say, took place long after the negotiations were commenced, even after the document had been provided.
Well, it would have to be an amendment to the agreement, wouldn't it? It would have to be a specific amendment to the agreement. That
has never been said.
Well, that must be their case. That by referring to FRS 308, what the parties were agreeing was that that particular part of the discussions was to be taken out of the English law without prejudice
Yeah.
protection, given the protection of FRS 308?
Well, that I think, this is why I've shown you
FRE.
paragraph 87, just to get the analysis coherent and logical, because their primary case is a distributed lex fori agreement, essentially saying, really there's no agreement here at all. Everything is just subject to the lex fori on whatever jurisdiction you end up trying to use the information. In fact, one then has to think, well, what is the position about non-litigious use of the information, which would require a contract to prohibit it? At what point can you rely on the lex fori to deal with that? But that was the first case. That was what they said here was their primary case as to the agreement right from the beginning. So essentially, there was no single system of law at all. It all just depended on whatever jurisdiction you happened to be in and what the attitude of the court was on that day to that document.
Well, that's just unsustainable. The analysis has to be what I put to you earlier, that there was an agreement at the beginning,
Yes.
and then if there was an amendment,
Yeah.
the analysis has to be that there was an amendment.
That was the alternative case, which they put at the end of paragraph 87, as I understood it. As they say there, right at the top of SUP 307. Alternatively, even if the use without prejudice was to be construed in accordance with English law, the parties expressly agreed a carve-out in relation to US law discussion, when they expressly agreed that US law discussions would be governed by Rule 408. And that, of course, is just a quotation of what Mr. Ayrton is recorded as having said in the minutes of the meeting, of the third London meeting. That appears to be the case, and for that purpose, can we look at, we could maybe just look at exactly what was said. And it's actually in the judgment, might be the easiest place to look, in the call bundle.
Well, it's the supplemental bundle at 85, is it?
Yes.
Yes, it is.
It set it out very clearly there.
Already, yes, that's the essay stated. So the statement is the meeting is a continuation of the confidential and without prejudice discussions between Ocado and Autostore, and that any US law discussions would be governed by Rule 408 of Rules of Evidence. The parties agreed there was no intention to waive privilege.
But I mean, how is it said that those words, any US law discussions were to be governed by Rule 408, negates the first part, which is this is a confidential and without prejudice discussion?
Well, that with respect is our point, that they can't have been intended, and were certainly never taken by the parties to have any such meaning.
It's an add-on. It's saying this is these are overall discussions which have been conducted pursuant to the rubric much used, which I've read out several times.
Yes.
And in addition, any US law discussions were to be governed by Rule 408.
That's what we say. And of course, it is a fact that US law discussions, in terms of a compromise negotiation, will be governed, because Rule 408 is
But
a
the
federal rule of procedure.
the truth here is that all that's irrelevant, because even the words without prejudice are actually irrelevant here, as are the Rule 408 rubric, because we're not talking about admissibility in proceedings in court. We're talking about use of the documents for another purpose.
Well, Lord, yes.
And it says on the top of the document, clearly, and it says at every stage everybody's refers to it, confidential and without prejudice, provided for purposes of settlement negotiations only. That's the key to it,
Yes.
isn't it?
My submission, yes. And it is notable that the email that comes back after the meeting, which you've already seen, from Bristol,
Says the same thing.
says the same thing in perhaps an even more lurid
Well,
term.
it says it twice.
Yeah. So,
It says
So
it
it's-
on the top and says it in the thing.
and it's talking about the very same thing to do with the US. So there's not a shred of suggestion anywhere in the evidence. I mean, there's not even a solicitor who comes forward and says, when I heard that, I immediately understood the position had changed.
It's just a classic example of people overcomplicating everything. I mean, it's just.
We would say it's a straw. It's perhaps not a straw in the wind. It's the kind of last plank to cling to, so far as this party is concerned. If it hadn't been for that statement, they would really have had nothing to go on at all, and they've built it into a suggestion that the entire contractual relationship was on a completely different basis from that point.
Misunderstands what a contract is.
So we submit really that was a poor argument. It would have been an extraordinary thing to happen at the meeting. Suddenly, the discussions, including in relation to a document that had already been provided, were going to take place on a basis that was unknown to the lawyers. I mean, they were not experts on US procedural law. And if we need a reason, I mean, it's not that it didn't make perfect sense to make that statement if we're right, because, of course, it is useful to make clear that the parties regard what's being said as also covered by 408, not least because 408 applies generally, whoever is trying to rely on evidence. So if, for example, material had fallen into the hands of a third party, 408 could still be relied on to make the evidence inadmissible. We can see that from the terms of 408 that the judge refers to at paragraph 22. I mean, the interesting thing is 408's actually got nothing to do, and it's irrelevant whether the parties agreed that something was going to be confidential or not. It's just a general rule about statements made during compromise negotiations not being admissible for certain purposes with certain exceptions.
So you don't need to stipulate that 408 applies. In US courts governed by federal rules of evidence, 408 is a mandatory rule, is that right?
That is right. But one can imagine, although I think US lawyers might think it sensible to refer to it. I think that may even be the evidence.
Well, it's for clarification.
Yes.
Our position is this will
Yes.
be covered by 408.
In other words, these are compromise negotiations, and thus whatever follows from that will follow as a matter of admissibility. But in no way does it derogate from the fundamental contractual obligations of the parties that they'd already agreed and plainly continued to agree and plainly didn't think had been fundamentally altered, as is suggested, with regard to an important part of what they were negotiating about, just by a stray statement at the beginning of the third meeting between these parties that was never followed up by anyone or referred to again until this application commenced.
Well, you say a stray statement. It appears, reading the statement of Mr. Ayrton, that abundance of caution might be one way of describing the
Yes.
approach. Else some braces might be a rather more colloquial way of putting it.
You're right. It's unfair and wrong for me to say it's a stray statement in the sense that it was just a throwaway line.
No, it wasn't.
It plainly was thought about, and he had instructions indeed to make the statement. But I was merely seeking to note that no one follows up on it and says, oh, right, we better watch out now. What we say, what does 408 actually mean? And so on and so forth. There is no further correspondence or discussion on the point at all. We say it's a confection, effectively, for the purpose of defending a very clear application, to say that this has the importance which is being advanced for it now by Autostore. So, Lord Almighty, that's what we say.
I mean, that's the long and short of the
that
case.
really
right?
is it. We say if you take our view, our submissions as to the right approach on interim injunctions in a case like this, the merits are strongly in our favour, and the judge should have done the right thing, which was simply to enforce the agreement in the interim, having regards to the strength and the merits of the case. Formally, I should address the question of the anti-suit cases, because it is...
that's the basis on which the judge decided against
that is the basis on which he decided it. Our primary point is, even if he's right, he should still have granted the injunction, because we did actually have... It was highly probable that we would succeed once one's done proper exercise of construction. But we also say that the judge was wrong to say that this was akin to an anti-suit case. And we've given the citations, if I just briefly show you that, in paragraph 18 of our skeleton argument on this appeal, of the relevant authorities from which the anti-suit approach derives. So that's tab 8. Sorry, paragraph 22 of our skeleton argument. And really, the key passage is the judgment of Lord Scarman of British Airways and Laker Airways, which is on core 84, our second point. Approach has to be cautious because the injunction restraining a person in jurisdiction from pursuing a remedy in a point, so it proves the relevant facts of cause of action is disguised, however disguised and indirect, and interference with the process of justice. So that's actually preventing someone from pursuing his remedy, which one can understand might be regarded as an interference with the process of justice, and it's on that reasoning that the courts, actually I think exclusively in the context of arbitration agreements and the enforcement of arbitration agreements, have taken this line.
Well, it's not just arbitration. You could have a contract under which you agree that the courts of England have exclusive jurisdiction.
Or an exclusive jurisdiction, I beg your pardon, or an exclusive jurisdiction clause, yes. But expanding it more generally to any injunction which would have the effect, to some extent, of interfering with some of the evidence which a party might want to deploy in a foreign action, is in our submission different in principle from an injunction which actually seeks to prevent the foreign court hearing the action at all.
It's almost an infringement of sovereignty. I mean, providing courts is part of the function of a sovereign state.
Yes.
And if you say these courts are open to people for these causes, for another country to say you can't sue,
yes,
although it's directed obviously at the party and not at the sovereign, it's in effect saying the foreign court can't hear it.
yes, and then that analysis we would submit requires essentially a brutal order saying the action can't happen. It's only at that stage that sovereignty gets interfering with the party's ability to deploy something that he would like to deploy in that action is an order of magnitude much less interference. It's not directed at the court's proceedings. It's an unfortunate effect so far as the party trying to use it is concerned with the agreement that they reached. It's never been applied in the cases that we've looked at. It wasn't. Prudential is inconsistent with it because it just talks about an arguable case. It's not mentioned at all by Mr. Justice Lloyd. Now, my learned friend says it wasn't argued. Plainly, that's right, but we would submit not argued for a good reason because it's a pretty hopeless point. We say the judge was wrong, therefore, to express the judge was wrong to conclude conclude that this was akin to an anti-suit case. I mean, he seemed at one point to accept that it wasn't as serious as an anti-suit case, and yet he nonetheless applied the same high probability test, which itself would appear to be an error of principle. We would say it's an error of principle in any event to treat this as any different from any other case where one's simply seeking to enforce a contractual right against using some information. So that's what we say on that point. We've dealt with it in our skeleton relationships.
You have.
Got my submissions. And I feel I'm overstepping my time,
Well, I think.
given the number of issues we've got to get through.
Well, I think we have your submissions.
I'm most grateful.
Oh, thank you.
Anything else?
Were there any other, I can't now remember, any other grounds of appeal that you relied on?
I think the rest of it, there were 4.
I thought there were more
Grounds,
than
I think-
2, but
Yes, I mean, I think I've covered 4, which was the balance of harm.
yes.
Your Lordship, Ladyship have got my submission on that. We say the judge got that wrong because plainly there was, however you look at it, equal harm on both sides by whatever he did. The right approach actually would have been to say, well, this only matters if this evidence is going to get admitted into the United States. And obviously the outcome of this is going to determine that either way. Yes, I think I've dealt with the other grounds. The rest of it, I think, is a matter for the respondent's notice.
Thank you.
Thank you very
Most
much,
grateful.
Mr. Purvis. Mr. Flynn.
I'd like to give the court 5 headline points first and then deal directly with the 4 grounds of appeal. I'd first like to put the application and the appeal in context. So my first core point is this. At the heart of this application is Ocado's claim in the ITC proceedings of equitable estoppel. The ITC trial is due to commence on the 2nd of August, so very shortly. Ocado say that Autostore made various assurances that Ocado did not infringe the relevant patent, and that as Ocado relied on those assurances, my clients are now estopped from asserting infringement. As matters stand, that is an issue in the ITC trial. Our case is that during the course of the WP negotiations, Autostore did assert that Ocado had infringed the relevant patent. And the equitable estoppel claim is therefore a dishonest one in the sense that Ocado knows it's false, but they say they're permitted to advance it because the evidence to show that it's false cannot be shown to the ITC judge who is considering the claim. And that is the underlying reason why they want the injunction, namely to prevent the ITC from seeing the underlying material so as to permit them to advance a case which cannot be controverted unless the disputed material can be admitted into evidence in the ITC trial. In other words, the claim of equitable estoppel cannot fairly be determined without regard to the relevant without prejudice material. Now, I should say there's one caveat to that. The Master of the Rolls mentioned that. Before Judge Hacon, Ocado put a point in a footnote to their submissions. They submitted that although it wasn't relevant, if all the material in the without prejudice discussions were before the ITC, then on their case on equitable estoppel wouldn't be undermined. And that was first made in a footnote in their skeleton. I'll give you the reference, but because time's short, I won't turn it up. It's in Supplementary Bundle, tab 46, page 261, supported by a footnote to Mr. Ayrton's 9th statement at paragraph 46, which is in the Supplemented Bundle 22 at page 135. The footnote doesn't support the assertion, and it's difficult to see how additional material can establish that Autostore weren't asserting infringement of the relevant patent. But as the judge records in paragraph 25 of his judgment, we made an offer to do that, but Ocado refused that. It wasn't acceptable to Ocado. Now, in my submission, that is a warning signal as to what is really going on. The underlying issue is whether Ocado can advance a knowingly false case in the ITC because the evidence necessary to demonstrate that it's a false case is said to be protected to such a degree that the ITC cannot itself determine the questions of admissibility in its own proceedings. Now, I echo what Lord Justice Nugee said. This is a question of sovereignty. Now, there are exceptions in the modern era to that, and there is a contractual basis upon which it can be done. But Ocado don't even assert that. It's not even their case, and I'll come to that. The second point is the balance of harm. Because if we're right and the judge is right on the balance of harm, that's a reason for the appeal to be dismissed. Because quite aside from the relevant test, the judge held that the balance of harm was plainly in favour of not granting an injunction. He dealt with that in his judgment, paragraph 72 to 74, and it is worth turning that up. It's in Core 1, page 27.
Just give us the paragraphs in the judgment.
Yes, it's paragraphs 72 to 74. I hope you have that. I wonder if you wouldn't mind the court just reading that.
Well, we've read it very carefully,
I'm very
several
grateful.
times.
So, in other words, even if this were an American cyanamide case, which it is not, the balance of harm is plainly in favour of not granting injunction. If no injunction is granted, the question of the admissibility of the disputed material will be dealt with in the ITC proceedings, which is the court in which the trial will take place. By contrast, if an interim injunction were granted, that would mean that the trial would go ahead without the relevant evidence before the ITC court. And on our case, the equitable estoppel claim couldn't fairly be determined without admitting the evidence into the ITC proceedings. Now, unless Ocado can show that that balance of harm is wrong, their appeal fails, because it's a point that applies even if the American cyanamide test is the appropriate one, which is not. That effectively reflects their ground 4. What they say in ground 4 is the ITC would inevitably admit the evidence on the basis of Rule 408. Now, firstly, there's no evidence that the ITC would inevitably admit the disputed material, even if it were to apply Rule 408 only. That is simply a self-serving assertion. Secondly, there's been considerable delay in bringing this application, and any problems that resulted from delay are of their own making. It wasn't the first time that they've applied to try and delay the ITC trial. You've seen that in Mr. Brinkman's first witness statement at paragraph 9. And thirdly, and possibly most importantly, it assumes without any evidence that the ITC court will only apply Rule 408. But if Ocado's case is that both 408 and without prejudice protection applies, then they can advance their arguments to the ITC judge for what they're worth. And that, in my submission, is why the judge is absolutely right on balance of harm. Because all that will happen is that Ocado will be able to advance its case before the ITC judge.
I'm sorry, Mr. Flynn, can
Yes.
I just ask you this?
Yes.
You keep on talking in your skeleton talks continuously about without prejudice and confidential and Rule 408.
Yes.
Why did your clients not agree that the document was produced for the purposes of settlement negotiations only, full stop?
So why did they not agree when?
Well, you say that you say it's all about without prejudice and Rule 408, but the document is headed for the purposes produced by your client.
Yes.
Several times your clients wrote, "We are producing this for the purposes of settlement negotiations only." Simple words.
Yes.
Why wasn't that part of an agreement with the other side, that was the purposes for which you were producing it only?
Well, the answer, my lord, is this, that is an issue that goes to the question of admissibility. On that basis, where would 408 come in? Our position is very clear in this, which is that the parties agreed that so far as the English proceedings were concerned, without prejudice governed, and so far as the US proceedings are concerned, Rule 408 governed. And that was done at...
And so far as everything was concerned, it was produced for the purposes of settlement negotiations only.
Yes.
Wasn't it?
But with respect, the issue here is twofold. One is the question of admissibility and the question of who decides. Now,
That's not the question at all.
I-
The question is a very simple one, Mr. Flynn, of what was agreed. And what I'm putting to you is that on your own analysis, it was agreed between Autostore and Ocado that this document was produced for the purposes of settlement negotiations only, full stop. And if that's right, how can you resist an injunction to enforce the agreement you made?
Because, one has to take it in stages. One plainly can, even if this were a purely domestic case, it wouldn't be automatic. The court would have to consider issues of admissibility. In other words, if it had nothing to do with anything other than domestic proceedings in England, and the parties had agreed those terms, the court is entitled to look at that to see whether it can be admitted for whatever purpose. So, with respect, my lord, that is overly simplistic analysis. That is not the issue, because the issue is what did the parties mean? There are issues of.
There's not even an issue.
No, I don't. No, I'm not saying it's not an issue. Of course, it's an issue. We've never said anything contrary to that. There are issues of construction as to what the parties meant. For example, did they mean, as we say they meant, without prejudice for the purposes of English proceedings of 408 for the US, or what was latterly said by Ocado? It's both. Now, in my submission, it's a surprising submission, as the judge himself found that was surprising. It wasn't what the document said. So far as the US discussions was concerned, that would be governed by Rule 408. Now, my point on this, Muddle, before I get on to the other points, is balance of harm. What is the harm in not having an injunction? In my submission, none. What happens is these questions are dealt with by the trial judge in the ITC. That judge can decide whether or not to admit the material on the basis of the case advanced by Ocado. If they're saying that the documents can't be shown at all because of WP, or because they've got a case under 408, they can advance that to the trial judge. So I do submit that balance of harm is, the judge was absolutely right on balance of harm. It's absolutely overwhelmingly in my client's favour because it doesn't preclude Ocado from running any arguments they wish to run. But my lord, the third core point is this, and with respect it hasn't been grappled with. In order for the appeal to succeed, Ocado have to point to a contractual right sufficient to justify a restraint on the ITC from considering the admissibility of the disputed documents for the purposes of the ITC trial. Now, this takes it outside Denny. In Denny, there was an exclusive jurisdiction clause. It's one thing to say that exclusivity has been agreed, that a party has a contractual right to exclusivity. That's not even asserted here. On what basis can this court preclude the ITC judge from considering questions of admissibility for the purposes of the trial in the ITC? Now, my lord, that is fundamental. It is fundamental. And it hasn't been, they now say in the reply skeleton, they've never suggested that there's exclusivity. It's not as if they're trying to get it in. They say it doesn't matter. In my submission, it matters a great deal because their analysis is the other way around. What's happened is, over time, the courts will enforce a contractual right to exclusivity, such as in Denny Brothers, or in the anti-suit cases, or exclusive jurisdiction clauses. But to get around comity, as Lord Justice Nugee indicated, it is a question of comity. The court modern day approach is to look at the contractual bargain and say, because it's a contractual bargain, it's an indirect interference. And if a party has agreed exclusivity, then the court can give effect to that. Now, my lord, that is not this case. They haven't done that here. They haven't even pointed to it. There's no pleaded case of exclusivity in the English court and no basis to give this court jurisdiction to do so. So, in other words, this court, the English court, is entitled to rule on admissibility, but so is the ITC judge for the purposes of the imminent trial. And there is nothing in my submission. I know your lordship says there's a great deal of material. There is a great deal of material here because it's very important to the parties. But that core point hasn't been addressed. Because you cannot get around the contractual need, the need for a contractual exclusivity by simply saying it's irrelevant. It's highly relevant because what this court is doing, if it grants an injunction, is interfering very directly in the ITC trial. Now, I'm not saying that's not possible. That is not my submission, never has been. But to get to first base, it is necessary to point to a contractual term that gives that exclusivity. Normally arises if there's an arbitration agreement or an exclusive jurisdiction clauses. They're treated as equivalent. But even if you have one, you must prove that to a high degree of probability. Because the court is effectively giving a final order. That's the consequence of the injunction. That although it's interim, it is effectively final. Now, there are safeguards against that. The high probability test, which is very high authority, is the test where that issue arises. Now, what is said against me is, oh, well, look at Denny Brothers. And I'll show you Denny Brothers, because I think it's very important to look at that case. It wasn't argued in that case because there was an exclusive jurisdiction clause. There was never an issue about that. There is an issue here, because it's not, there is no case of exclusivity. It's not even, in my submission, I said to the judge below, and I stand by it, there's not even an American cyanamide issue, because they haven't advanced it at all. It's not no part of their case. Now, well, that is very, very important.
So what do you mean by there's not an American cyanamide issue?
So even, my lord, there's no issue. So even if the test was serious issue to be tried, so the very lowest scale. Now, in my submission, there are many reasons why that is not an appropriate test in a case of this kind. We say high probability. The alternative is under the Human Rights Act, which is more likely than not. Caution. All the cases say that. So in my submission, it is not possible to say this is an American cyanamide case. It is not an American cyanamide case. But even if it were, even if it was serious issue to be tried, there's no issue. There's not even a serious issue.
But it is an American cyanamide case, because American cyanamide, if my recollection is right, and I have a feeling it is, takes account of cases where the outcome is determined by the interlocutory injunction. And it says that you then consider who has the best of the merits, and you don't simply look for a serious case to be tried.
Well, even if it's serious issue to be tried, which I don't accept, because I'll come to why that.
Well, maybe the first hurdle. I think I gave a judgment some years ago about this. Even if the first hurdle is serious case to be tried under cyanamide, you then go on in considering the balance of convenience to consider the merits in much greater detail, because for an injunction that has final effect, you need a better case on the merits.
Yes.
And obviously, and that's what the Foods case says, and that's what Lord Justice Chadwick said, and it's just obvious.
Well, this is a different case because it's not your run-of-the-mill case, and the reason it's not
It's not what?
It's not a run-of-the-mill case because they're saying you should preclude the ICC judge from admitting evidence into the judge's own trial. Now that engages exclusivity. The courts don't lightly interfere with other courts. They can do if there's a contractual term. Now, it's never been part of our case that the English court has no jurisdiction to deal with the English proceedings, and there cannot be a final claim in relation to that. But this is carved out the US proceedings, and it's a.
Can I just put
Yes,
it
of
to you?
course,
Just slow down for a second.
I'm
Mr.
so sorry.
Flynn. It's not really about whether we restrain the US judge from admitting evidence into his proceedings. It's whether we restrain you
Yes.
from contravening your agreement not to use a document for any other purposes than the purposes you agreed.
Yes.
So it's an inter partes. I mean, I take the point that the effect is as you say it is, and you put it dramatically, that's the effect, and it's effectively an injunction on overseas activity and proceedings and an intrusion into the jurisdiction of the American court.
Yeah.
But the reason why there is an intrusion into the American court is because you agreed you would only use this document and the negotiations for one purpose. Now, that is effectively something you agreed in England.
Right.
And
I totally understand this, but may I say there's quite a lot I can say in terms of. Can I answer you the question as you put it to me?
Yes.
I don't accept the premises, but let me just put it that way. So let's say a party agrees that they won't use a document for any purpose. Now there'll be a lot of arguments about whether that's possible and so on. But assume they've agreed that as a contractual term.
let's assume.
Right. Now let's assume that. Now we don't say that the English court cannot ultimately decide that, provided there is otherwise jurisdiction to do so. So let's say it's English parties in England. That is not the issue here. The issue here is on what basis is the court preventing another court. Now, the analysis in the cases is very clear. It's not a direct interference in the court. It's an indirect interference that restrains my client from adducing material in evidence. So that is the analysis. But the effect of it is that the effect of the injunction is to preclude another judge from determining an issue for the purposes of this trial. And it is possible to do that, my lord, but it is not enough to say, I promise not to use this document for any purposes. It has to be shown that the English court has, where will the issue about admissibility be decided? Now, it's very easy for the English court to assume that it has a jurisdiction. It certainly does have a jurisdiction, but it doesn't have an exclusive one. On what basis can this court prevent the ITC judge from considering that issue? All the issues that your lordship has just put to me, whether there was a promise, whether there are exceptions, whether it should be admitted into evidence, on what basis can that be done? Now, we have never said it can't be done in principle. You can have an exclusive jurisdiction clause. You can agree, I promise not to refer to this document. Insofar as there are issues of admissibility, I give the English court exclusive jurisdiction. And that is why the anti-suit cases come in, because an anti-suit is effectively a promise not to sue elsewhere. There's no promise here not to sue. There's no promise not to ask the US ITC judge to determine this question of admissibility.
What's the difference, Mr. Flem, between promising not to sue elsewhere and promising not to deploy a document in evidence elsewhere?
The answer is, what I think your lordship's getting at is there are two things in this case. One is admissibility, whether there's been a breach of the agreement not to refer to the document, and how you determine that.
I wouldn't regard whether there's been a breach as raising a question of admissibility. Admissibility is a question of the rules of evidence and is a matter for the forum. I don't think anybody disputes that in the ITC, the relevant rules of evidence are the federal rules of evidence.
Yes.
Obviously, the English court can't tell the ITC what its rules of evidence are or how they should be applied. But the English court's not being asked to do that.
No.
The English court is being asked to stop a party from breaking a contract. It's not disputed. The English court has jurisdiction over the contract.
Yes.
In an anti-suit injunction, the court is enforcing a promise not to sue anywhere else.
Yes.
In this case, we're being asked to enforce a promise not to use a document anywhere else. And my question is, what's the difference in principle?
There is a difference in principle in my submission, which is that unless you've got exclusivity, any questions that arise about admissibility, this court, the English court in these circumstances, cannot prevent another court from determining that question about whether there is a contractual bargain, whether it applies to the particular document, and so on. It can't simply say there's an arguable case that you promised not to refer to this document, and therefore I can prevent you from going anywhere else.
But I don't see why not. I mean, in terms of jurisdiction,
Yes.
the judge has decided to give leave to serve act. Your client is Norwegian
Yes.
and has not challenged the fact that the English court has jurisdiction to enforce what, on the face of it, there are good grounds for thinking is an English contract.
Yes.
All the English court is doing is saying, you promised not to do this, don't do it.
No,
That may have a knock-on effect of what gets before the ITC, but it's not.
Well, can I put it this way? It confuses, in a sense, the difference between interim relief and final relief. If the issue had been finally resolved at a trial, as they're asking for, in their claim form, that would be a different situation, because there would effectively be an issue estoppel on the contract. The contract will be finally determined, and one can see in those circumstances you can issue a final injunction. The difference here is it's interim relief that has the effect of being final. So it's doubly cautious, because what your lordship is actually saying is, well, if there's a promise not to refer a document, that imports into it the question of exclusivity. It's not that the English court doesn't have jurisdiction. It's that the ITC court also has jurisdiction. And you can only prevent that clash of jurisdiction by injunction if there is remember, it's all put on a contractual basis. It's not about, your lordship said about the without prejudice rule and the rules of procedure and so on. As Lord Justice Chadwick made clear, and I think this is what he was getting at, was the restraint is for the contractual promise.
Yes,
in other words,
public policy is a matter for each country's court. Yes.
So
this is not put on the basis of public policy, it's put squarely and fairly on the basis
of contract.
This is what you promised to do.
Yes.
Please, court, grant an injunction stopping you
Yes.
from breaking your promise.
And
That's the very simple basis on which it's put.
And I think the answer to your lordship question boils down to a nutshell answer, which is this is not the only court In other words, there is no basis for this court to prevent another court from doing the same exercise. I accept that if it went to a trial and the trial had produced an issue of estoppel, that would be a different matter.
Well, can I put it to you this
Yes.
way? You said, in answer to my lord, that it's not about whether the English court has jurisdiction, but it's about whether the American court also has jurisdiction, and you say it does.
Yes.
But this all started with my lord asking you, what's the difference between a promise not to sue elsewhere and a promise not to use a document elsewhere? And the fact that the other court also has jurisdiction is essential to the question of when you promise not to use that jurisdiction elsewhere, as it is when you promise not to use a document elsewhere.
There are two answers.
So there isn't, well, if I can just finish
Sorry,
the
I'm sorry.
question. So there isn't a difference for this purpose, is there?
There is, my lord, in this sense, there are two answers. One is, well, Justice Davies's point, which is one that I'm coming to, that what is lost sight of in all the submissions. This was subject to the US Rule 408, expressly agreed to be subject to Rule 408. Now, there are two distinctions on Denny Brothers. One is that had an exclusive jurisdiction clause, and the other is there was no reference to Rule 408 or some other foreign rule of evidence. Now, what the English court would be doing by giving an injunction is to arrogate to itself any issues that arise in relation to that agreement, to that contractual promise. Now, in my submission, that can only be done if there is a promise of exclusivity. Absent the promise of exclusivity, there is no basis for precluding the ITC judge from making a similar determination. Put yourself, in the boots of the ITC. Imagine if this were before the ITC judge, and there were an injunction to say restraining admission of the document before the English court. Now, the ITC judge is in just as sound a position to determine these issues as the English court. And the only way in which the English court, in my submission, can preclude that is by reference to exclusivity that's not alleged. And you can't jump that hurdle in my submission. Now, as I say, it's said against me that I allied a number of things. I don't allied anything. What's allied against me is the difference between a contractual promise in relation to a document and the issue of how any issues that arise in relation to that, where they are to be determined. And also the distinction between interim, albeit in this case with the effect of finality, and what would happen if this matter went to the full trial and the court ruled before any other court and an issue of estoppel was created. Now, I know your Lordship says it boils down to some very simple issues. They are simple in one sense, but they're not simple in favour of Ocado. They have not pointed to the essential element that they must do, which is the exclusivity. And they now disavow saying, they say, they've never suggested that, but it's irrelevant. It's not irrelevant. It is central. And in my submission, it turns the position on its head, because, as I say, the authorities that we set out in some detail, the comity issues that arise are very important.
I mean, Mr. Flynn, I accept, for the sake of argument, that if there was an agreement as to Rule 406 or whatever it is, you could legitimately say that there was an agreement that questions of admissibility in US proceedings would be decided according to US law.
Yes.
So let's park that,
Yes.
because obviously that's what you allege was the effect of the amendment to the agreement. But how does that overrule the very simple agreement not to use the document for any other purposes? Now that's the problem I have, because that seems to me to cut through at the moment your very powerful submission about needing to have an exclusive jurisdiction clause. You don't need to have an exclusive jurisdiction clause if the agreement is a blanket agreement covering the whole world. Now, I know you say it isn't and it wasn't, but if that is the proper interpretation of what was agreed, then it sinks you, doesn't it?
No, it doesn't, my lord. But let me come back to that, because that aligns a number of other issues. The cases show that by use of the term without prejudice, you can imply a contract. That's what they say, imply. Now, the issue about the Rule 408 is this. Our cases, they separate. You carve out. English law doesn't help you by saying it's governed by English law because English law allows you to carve out for the US proceedings. So we say the obvious answer is, without prejudice to English, that 408 for US. That's what the parties agreed, that's what they intended, it's in black and white. The judge is with us on that. There was an argument against us that it was both. The judge rightly has some scepticism to that because that's witness statement evidence that controverts what the document itself says.
None of that gets over my point.
Well, can I just, let me take it in stages, because firstly, you can't imply that agreement in the face of 408. So it's not the normal case, like Denny's, where you have an implied agreement, because it's all essentially English law, or it's only without prejudice. There's no reference to 408. So what your lordship is saying to me is, but if there's simply a promise not to use the document. Now, the question then is, well, why is it the English court that has the sole right to determine that question, whether it does mean that? This is not the trial. This is for the purposes of interim relief, the consequence of which is to preclude another judge in another country and related proceedings from considering the issue. And in my question, I'm afraid to turn it round to your lordship, is how is that addressed? How does that come out of the promise? It doesn't. You need another stage, which is to say that it's the English court that decides that issue, whether there was such an agreement, what the effect of that is agreement, could it be overridden for particular purposes?
Well, I mean, I think it's accepted that this court has jurisdiction to decide this application.
Oh, of course, my lord, and I've never suggested otherwise. But it's about comity. Yes, this court does, but why doesn't the ITC court?
Well, it may well do, but if we're deciding the question of whether you agreed and whether there should be an injunction to support the agreement that you would not use the document anywhere, then obviously it's got to be the court that's considering that, which is us.
No, but no, that's, in my submission, that's not right. It's not a race. It might be a race when it's finally decided at a trial, but for interim relief, if two courts have an equal basis for exercising jurisdiction, in my submission, absent a contractual right to exclusivity, neither court is permitted to preclude the other court. So what is happening? In my submission, what is happening here is an attempt to arrogate to the English court exclusivity which it does not have, even in the face of an agreement not to refer to a document. Because this is at the interim stage, and issues about how one approaches that agreement, whether there is such an agreement, and so on. Now that, my lord, is even in your lordship's pure point of principle, if I can put it that way. But we're very far removed from that, because here we've got no exclusivity, but we do have a reference to 408. Now, in my submission, the highest that Ocado can put it is both. And as I say, the judge was rightly sceptical about both. In my submission, it doesn't make practical sense, but that's the case against me. Now, again, if it's both, that makes my submissions even more strong in my submission, because why should this court be determining issues about 408? Plainly, on that basis, my lord, 408 would never arise. The US courts would be precluded from applying their own rule under 408 because the English court has granted an injunction. It would never arise. It would be contrary, in my submission, to the agreement of the parties, because plainly they did agree 408. And one of the issues, as the judge said, is, well, what did that mean? Our submission is it's the equivalent of without prejudice in the US, so that's why it applies to the US proceedings, and without prejudice applies to English. There's an issue about that. But on what basis can the English court arrogate to itself the right to prevent the ITC judge from considering 408? I mean, it's contrary to Ocado's case, because they said they expressly wanted that term in because of the US proceedings. Now, on this basis, they've never...
The answer I keep on giving you, but you reject as being of any significance, is because you actually agreed that they shouldn't consider anything. You agreed that the document, you would not put the document in play for any other purpose than the discussions. And that included putting it in the US proceedings.
My lord, can I would never reject anything your lordship says as not being significant. It's obviously of great significance. but I do want to address this issue because I know that your Lordship from the questioning approached it in that way, and it is so fundamental in my submission that if that's right, it denudes that clause of any effect whatsoever. Now,
It
Your
denudes
Lordship,
the
408
clause.
never be considered. Now, my Lord, that might be a possible answer. I would say in my submission, the least likely of all, that there was never to be consideration of 408. The highest against me in my submission is it's both. I don't accept that argument, and I've made my submissions on that.
I mean,
But that's
these were not American lawyers, but I take the point that it denudes 408 of any real significance. But it might be said that, as my lady put it, actually, at one point, that when they were referring to 408, they were thinking, well, we need to supplement without prejudice with 408 in American terms.
Yeah.
So it's belt and braces.
Well, I don't accept belt and braces. Let me tell you what was said, the exact wording, what was agreed. Any US law discussions were to be governed by Rule 408 of the rules of evidence.
You've missed out the word "and."
But
The question is whether those words "and any US law discussions" mean in substitution for the English without prejudice rule, or mean in addition to the without prejudice
that's
rule.
my lord, and I absolutely
That's
I agree.
it in a nutshell, isn't it?
I agree with it, my lord. But my case gives effect to that.
Well, can I add
It
to
does-
that? It's
yes.
not in addition to the without prejudice rule, it's also in addition to the rubric that it won't be used for any other purpose.
Well, that is about construing the contract. That's all a question of what the contract means.
Well, so is the point my lord raised. or
Yes,
we raised.
but are we not in as good a position? I put this to Mr. Purvis. Are we not in as good a position to form a view as to what the contract means, even if not determine it, because this is not a trial, but as my Lord Master Earl said, evaluate what we think the contract means in as good a position to do that as someone would be at a trial?
No, I don't accept that.
Why not?
Well,
It's just the words on that page.
well, this is interim relief. We're not at the trial.
I understand that, and I understand that very often there's background material and matrix of fact and other matters admissible on questions
Yes.
of construction which you can't be confident at an introductory stage you have all the material. But in this case, all we're looking at is a run of emails, all of which are marked without prejudice and confidential and for negotiations only, and a statement which it's not been suggested has been wrongly recorded at the beginning of a third meeting, which says, without prejudice and confidential and for negotiation only, and any US law discussions are subject to 408. Why can't we decide what we think that means?
Can I take it into a couple of stages? One is, I don't accept that you're in a position to decide that these are matters of great significance and there will be a lot of background evidence and so on. And indeed, there's evidence put in on paper which was was viewed with considerable scepticism by the judge.
I think Mr. Purvis accepted the statements as to what people had in their mind.
Subjective.
Is not likely to be admissible.
I agree. But the question your lordship asked
But
me
you said something about this factual matrix. I mean, you can't just wave your hands with great respect, Mr. Flynn, and say there are loads of things that might be relevant.
Well,
you have to give us at least a concrete example.
Well, one of the things that was said in the evidence was that they weren't waiving privilege on what happened and why. They'd obviously consulted with their US lawyers before they agreed that. Now, there may well be a massive debate about whether that should be opened up to fairly hear the trial. What was their intention? What was their advice? That's one example. The timeline is another example, exactly what happened when. In my submission, there's enough here to see that there were plainly US proceedings in prospect, and therefore plainly the 408 would be applicable to those. The only question is, would it be also without prejudice? Now, that, in my submission, is not something that this court should... what it feeds into is coming back to this test then, which is high probability. Now, that's why you have a test of high probability for exclusivity. Now, I know I don't want to labour this point, but it does get forgotten. The court is in as good a position as the ITC. The ITC can make a resolution just as this court can. Why should it be this court, which gets there first because Ocado apply here first, rather than the ITC judge deciding those matters? So it doesn't really answer the question as to why this court should preclude another court from dealing with that when the trial is in the ITC in August. So both courts are in equally good a position. Now that feeds into the question.
What happens if you have conflicting decisions
Well, that's
as to what is the meaning of won't use it for any other purpose?
well, that in a sense, that I would adopt that, which is you might have differences of views. Why should the first in time prevail, especially at the interim stage? I mean, one can see if you have a trial, that's a different matter.
That's the way the world goes round.
Well, I don't accept that, because in the absence of exclusivity, I wouldn't be having this debate if there were exclusivity. If there was a statement that the English court...
there are cases, of course, where the English court makes a decision and the US court decides not to respect it. And I was involved many years ago in cases of that kind between Caribbean courts and the US courts.
I see that, Miles. I just don't think this is appropriate for this case. I don't see why we should get into that. Why
can't we decide a contract, the meaning or the implications of a contract that was made here between English solicitors relating to English proceedings and, as it happens, other proceedings?
So you see, I think the answer is this: that's an American cyanamide test as to on an interim basis for an injunction that has a final effect, precluding another court about to go to trial from considering that issue. I've never said that the court doesn't have jurisdiction.
No, because we could do an anti-suit injunction if we wanted to.
Yes,
as you said.
but I do say that in principle, but you can't in this case because there's no exclusivity provision.
Well,
Not
Mr.
even
Flynn,
alleged. So.
Mr. Flynn, in a very short time, we've got to the heart of this case. So maybe we'll take an hour to, what should we say, cool off and
Yes.
come back at 2 o'clock.
I'm very grateful.
Thank you.
This is fun.
Yes.